You are still tuned to Owanapaedia, your one-stop center for the history of this country. This is Tony Geoffrey Owana, and Herbert Semiano is in charge of operations there.
Tony Owana really loves our history. He has a passion for doing research, and he shares all this history with you, so that you can make informed choices.
Banange, have you subscribed to Owanapaedia? I don't know what you are waiting for.
This is what I'm going to say. They say, "Oh, when time you feel it, that is to say, a peasant loses a sheep, his sheep gets lost. Now, when the sheep gets lost, then at the same time, a hyena passes excreta, which contains hairs of a sheep. Now, according to the Munyankore, that hyena is guilty. This was the traditional concept of guilt among those gentlemen.
President Museveni, in his address to the lawyers, demanded that those whose hand is caught in the till, these thieves whom you complain about, once caught and convicted, their assets must be grabbed and sold. There are people who propose it today like it has never been proposed before. The president even went further and demanded that for public servants who fail to deliver, there must be a penalty for punishment for failure to perform. This is how the president presented his case to the gathering of distinguished lawyers. Over now to Owanapaedia at Conference Center, 1987.
We calculate how much damage you cause the state, and we sell your property, and we recover our money. Not just lock you up and things like that. These are irrelevant because the state has lost. What does imprisoning you help or dismissing you? The money has been lost. The state wants its wealth to be brought back. You caused it a loss. You must pay. This is my simple man's logic. There is at present no offense covering a public servant who neglects his duty and causes loss to the public. Now, this is the most infuriating part. This offense must be created, and any person convicted of it must not only serve a long period of imprisonment, but must also compensate the public for the loss incurred. Partly through the impotence of our laws, criminals have been encouraged to commit crimes, and so it has been left unprotected. The NRM government is determined to use strengthened criminal law to defend our people against embezzlers of their money, wreckers of the economy, and other criminals. If our society is wrecked by criminals, let loose on it, even that innocent person may not be saved. In this connection, the rule which presumes an accused person to be innocent until he is proved guilty should be re-examined. I'm not saying that it should be scrapped, but I think it should be re-examined. There should be some other control somehow. Through long usage, this rule has become so natural that it appears as if it was ordained by God. It is in fact not universal and does not apply in many countries. That's the fact of the matter. We have discarded other things which also appeared natural, such as hundredweights, stones, gallons, pints, etc., in which we were drilled when we were young. We are now using kilograms and other things. I believe we can discard this rule too. This rule of presumption of innocence has the logical consequence of placing the burden of proof on the prosecution. And this burden is so heavy that if the prosecution does not prove its case beyond any reasonable doubt, the accused will be set free. The accuser does not have to say anything in his own defense. He can just keep quiet. I can just come in court and I say, look here, you are the one who's accusing me, prove that I'm guilty. And I just keep quiet, and then it's up to you. If you fail to prove that I am guilty beyond all reasonable doubt, then I am free. This, in my opinion, is wrong and goes contrary to our traditional concept of justice. The person, you see, I'm fond of quoting Banyankore proverbs because I'm so steeped in that culture of those gentlemen. But it is so rich with so many philosophical and legal. This is Banyankore have got a saying, they say, "Obwenta mefire, emptin wene irevyoya." That is to say, a peasant loses a sheep. His sheep gets lost. Now, when the sheep gets lost, and these are philosophical and legal concepts evolved by those gentlemen and ladies in that part of Uganda. Now, somebody loses a sheep, kondoa. Then, at the same time, a hyena passes excreta, which contains hairs of a sheep. Now, according to the Munyankore, that hyena is guilty. Why? You see, this was the traditional. This was the traditional concept of guilt among those gentlemen, because my sheep got lost, and roughly around the same time, when my sheep got lost, a hyena passes excreta with some hairs of sheep in its feces. Therefore, the hyena must be guilty. Otherwise, a person accused of an offense always defended himself in some of the traditional societies. I'm not very familiar with all of them, but definitely like the one which I'm very familiar with, you had to defend yourself. You could not just sit there and just say it is up to the accuser to prove your guilt or otherwise. In fact, the more unwarranted the accusation, the more the accused would have to speak in his own favor. Even with societies which have a perfect machinery for investigation and prosecution, this rule is not good. With us, however, it is absurd because we don't have a good machine of investigation. We don't have. The other day I was talking with a certain foreign diplomat, and we were comparing notes. We don't have lie detectors, for instance. Do you have lie detectors in the police department? Because in America now they have got machines called lie detectors. When you're interrogating somebody, you can have this machine which can show you that this man is telling lies. Or otherwise, I don't know whether they have them here. We don't bug people's houses. We don't have electronic eavesdropping capacity, which the Western countries have. They can just listen to you in your bedroom, wherever you are. So really, we are putting a very big burden on the police, even if the police was good, which of course is also not good. But assuming it was good, it would still be a difficult job. So if you use ultra-modern concepts in a backward situation like this one, you could cause problems for yourself, for your society. It guarantees freedom to a bigger percentage of criminals who are brought to trial. I think it should be changed so that an accused also has a duty to defend himself. I'm not saying it should be entirely scrapped, but let's examine it. Let's be open-minded about it. He should not necessarily be required to prove his innocence beyond reasonable doubt, but he should be required to defend himself. In a situation where the government is fully committed to the rule of law, the state has no interest in persecuting innocent individuals. Usually the person arrested by the police or members of the public is not entirely blameless and has something to answer for. People cannot really just arrest you for nothing. Even the Europeans have got a saying that there is no smoke without fire. I think that was also evolved because of their own experience. In the event of a mistake being made, the accused can defend himself in court. The court, after all, plays the role of arbiter between the prosecution and such an individual, and it can satisfy itself that he is innocent without calling in its aid the heightened statement that the prosecution has failed to prove its case beyond any reasonable doubt. Bail is another area of our criminal law which must be re-examined. And this bail, I've been having a lot of difficulties with our soldiers. They cannot understand bail. They really don't understand, and even yesterday I was explaining to them. Somebody was found with a gun and he's bailed. That some law says that legal possession of a gun, illegal possession of a gun is not is a bailable offense. Really, this is discrediting the legal profession in the eyes of the National Resistance Army. This I can tell you separately. These fellows are saying that these chaps are not serious. What was he doing with a gun? And why must he be bailed? You see? How many people will die because of this? If a man had a gun illegally, what did he want it for? For some crime, political or criminal. Now, why should this man be bailed? The National Resistance Army people cannot understand this. You see, they cannot understand that. They are completely perplexed by all this. Members of the public go to great lengths, sometimes even risk their lives. Our committee men risk their lives to arrest, to report somebody with a gun. He is taken into court, 2 days, he's bailed out. And as far as they are concerned, he's freed. You see? In fact, recently I had a very interesting case. One old man had his cows had been stolen by some other person. Then eventually he found the cattle. So they were taken to the police station as exhibit. And being taken to police station as exhibit, they are put there in the town, you know, to stay feeding on the cassassery in the town. Then the man, the thief of the cows, was released on bail. So this old man came and asked me, who has committed a crime, the cows or the thief? You see, because according to him, the cows were in prison, they had been imprisoned. And the thief was at large. So it could not make any sense to this old man, and I could not answer him. You see, this is the sort of danger you can find yourself in with these half-baked. So these members of the public go to great lengths, sometimes even risk their lives, to apprehend a criminal, only to see him walking a few days later a free man that has been bailed. They are told in disbelief that he has been released on bail. Immediately, the accused sets about destroying evidence by bribing some key witnesses or threatening them or liquidating them altogether. And our police is not all that efficient to protect everybody. Our police is not efficient to protect all our witnesses. It is not omnipresent. It's not omnipresent. Somebody can go and kill somebody in the villages. As long as he's got a gun, we don't have a police to cover all our population. His chances of ever being convicted become very slim indeed, more so when this is coupled with the burden of proof on the prosecution that is ever so high. The Attorney General and the Law Society should do research on this and find out how many accused persons are convicted out of a total number of those who are released on bail. You could carry out a research. If you are released on, if those people are being released on bail, how many of them eventually get convicted? This is ascertainable. You can find out exactly this ratio. I have no doubt myself that the percentage is very low. The moment you are released on bail, then you have got freedom of tampering with the evidence and intimidating witnesses. The rule which prohibits creations if offenses or enhancement of sentences retrospectively is sometimes that should be reconsidered in the light of gross violation of human rights that we have gone through. I'm still aware of the Law Society's vehement opposition to the Human Rights Bill of 1980, which sought to punish those who belonged to Idi Amin's state organs of murder and terror. You opposed it, among other things, on the grounds that the bill was retrospective. I believe that if that bill had been enacted into law, we would have been spared some of the atrocities committed by Obote's security organs, or at least would have had a ready law to try those who used these organs to perpetrate atrocities against the people. As it is, we now have no law to try such people just because of some principles which is regarded as sacrosanct. Our responsibility to our people is not only for the future, but also for the past and present. People see with disbelief those who terrorized them walking freely and cannot understand why they should not be prosecuted. It should be realized that failure to redress such grievances results in people taking the law into their own hands or in loss of confidence in the government to which they look for remedial action. We have got to act. You see, because we are not going to guarantee the future without punishing the past. For instance, although this is politics, I have been subjected to some pressure from some quarters saying that we should pardon all the criminals of the past, that we should forget. For instance, a bishop, this gentleman, Ogwar, Mr. Ogwar, the bishop of Gulu, I believe, of northern region. This is a man of God. He's a bishop. I think he hopes to go to heaven before I do. I have met this gentleman twice. First, it was in, I think it was March or April when I went to Gulu. Then recently in December when I was there. Every time he comes to me, his emphasis is to forgive the criminals. Then I asked Ogwar, I said, Mr. Ogwar, if I forgive those who killed in 1974, in 1972, in 1980, in 1981, 1983, how will I then punish those who are committing crimes today? How can I punish the soldiers of the National Resistance Army who are committing crimes when I have forgiven the ones of UNRA and the ones of Uganda Army? How? Will it be that the criminals who supported me politically will be punished and those who opposed me politically will be forgiven? That would be the only logic. So, and I told Mr. Ogwar that if you are really interested in reestablishing peace here, there cannot be any criminal excused on political grounds. All criminals must be punished. That is the only way we can establish peace for the future. That's what people are doing in Argentina. I think you hear the situation in Argentina. They are going backwards and getting hold of all those chaps. Former presidents, former this, they get hold of him. I'm not threatening. But so that you see, if we do not punish the criminals of the past, I can tell you it will be difficult to guarantee security in the future. It is not easy to guarantee security for the future without punishing the past criminals. At least, even if you don't punish all of them, you can excuse some of them depending on the degree of responsibility of crime. But to say that all of them should be excused unconditionally is very unwise. It will endanger the future of our country.
Did the president speak of failure to punish? There is one man who will never forgive the president for his part in failure to punish, and that is Museveni John Nagenda, who was a member of the Commission of Inquiry into the violation of human rights which the NRM government set up when it had just come to power to look into atrocities committed against Ugandans from independence to 1986. The Nagendas did their work thoroughly. They gathered testimonies of victims, of perpetrators, of suspects, of all types of people. And this was at first thought that it would be some kind of a Nuremberg trial, like the one they held after the Second World War against Hitler's people. After they had gathered all this voluminous information and evidence, the president in his wisdom dictated that the report should be shelved for the cause of reconciliation. Now, as far as Nagenda is concerned, the perpetrators of these injustices and crimes should have been punished rather than reconciled with. Now, the president was looking at a bigger picture of forming a government in which some of the alleged perpetrators were members for the sake of peace. Now, that is a compromise which Nagenda believed he could not live with. We managed to interview John Nagenda himself, and he can say it loud and clear.
Now you are in the Human Rights Commission.
The Human Rights Commission.
And you consider it a very important
It
part
is the,
of what you have
It is
done.
the only thing I asked to be in.
Yes.
I didn't have any interest in being minister ever. Now, hear what is really gruesome to me.
Yes.
Every effort was taken not to have a report, which took us 9 years, including writing up. I've got the books there. There are, I think, 14 volumes of an average of about 800 pages. It's there in my house. It was sat upon by this government.
Why?
I know why.
It's going to gain from
I know why. Because the top leadership thought forgive and forget. Or take it, over forget and forgive.
As a direct result of not having punished some of the perpetrators of those deeds, when you look at some of the narrators of history today, they even have the liberty of pointing their accusing finger at Yoweri Museveni and his colleagues with whom they participated in the struggle of 5-year Bush War, and they accuse them of some of the crimes that are actually covered in the report of the Uganda Human Rights Commission. John Nagenda would have had the last laugh if it was something to laugh about, but today it gives historians a bad taste in the mouth to find President Museveni and his NRM being accused of some of the very things that took them to struggle against that former regime, and they can't defend themselves because the record was kept silent for reconciliation. When we get back, the president will delve deeper into what he calls legal gymnastics, which he accuses of confusing ordinary people to the extent that they get tired of the law. Owanapaedia in charge.
Owanapaedia, Owanapaedia, Owana for history. If we go, Owanapaedia,
Banange, have you subscribed to Owanapaedia?
for history.
I don't know what you are waiting for.
Owanapaedia, Owanapaedia, Owana for history.